and welcome to another edition of Demystifying Your Transition. My name is Julie Hollinger, and I'm the Programs Manager at the Petawawa Military Family Resource Center. I am here with Jeremy Bertrand and Louise Anderson, and we are here to do another part of our Demystifying Your Transition series. This is a series of workshops that Louise Anderson had an idea for as she was working with clients in the Veteran Family Program, and as they were going through the transition. Louise realized that there were a lot of family members that maybe weren't getting the information about the process and wanted to put together some very simple little workshops that people can go back and review periodically just to get that information and to introduce some folks in the community that you can ask your questions to if you don't really feel that you're getting the answers that you need. So Louise is always there to answer questions as a Veteran Family Program Coordinator. And today we've invited Jeremy to join us. You may recognize Jeremy. We have talked to him before. We spoke in an earlier session about finances. And as we gone through that session, we realized that there was a whole other part of the equation that we had not touched on. So we had wanted to come back and do a separate session on wills and estates. Before we start, I'm just going to let folks introduce themselves. Jeremy, do you want to introduce yourself?
Yeah, sure. So I've been a financial planner here at SISIP for about 3.5 years. Certified financial planner since about 2012, early 2012. I also hold the Chartered Investment Manager designation, Chartered Life Underwriter, and a few others as well. So again, at SISIP, what we're really trying to do is help our members, right, start investment plans on understanding and implementing their insurance needs, as well as financial, personal taxation, along with many other areas of financial planning. And that kind of brings us up to the topic of today, where I developed a keen interest in will and estate planning, and I think it's a great subject to broach today.
Perfect. Louise, do you want to introduce yourself?
Yes, my name is Louise Anderson. I'm the Veteran Family Program Coordinator here at the PMFRC. I'm one of 32 across the country. Most of my time with the MFRC was spent in employment services, but when this program stood up in 2018, it was something that was really, really close to my heart, and I really wanted it. So I went for it, and here I am.
So really familiar with those transition times in a person's life and helping them make those big life changes. Jeremy, so you are a financial planner. You're not a lawyer, but you have this in sort of this tangential interest because you're talking about people's finances, their portfolio, and then what happens to them afterwards. And we're talking about wills and estates. Do you want to just talk about what the difference is, just so we weren't throwing terms around, we're all sort of thinking of the same thing when we're using these words?
Absolutely. And that's a great point that you brought up. So I always disclose that, first of all, that anything I say should not be taken as legal advice, and that you are reminded to always speak to a legal professional regarding your specific circumstances. But sure. So basically, at the end of the day, what an estate is created when an individual passes away and is quite simply the sum total of that individual's net worth, including all property, including real property, possessions, and other assets. Now, not every asset is going to land in the estate. You kind of think of it as like a little black hole. So some assets such as RSPs and TFSAs or RIFs, you can name a beneficiary on, and they might not land in the estate per se. They can go directly to a individual that you name within the plan. However, if your plan, or if your estate plan is not carefully structured, most of the assets will form part of the estate and may be subject to a fee or a tax levied on those assets before they can be distributed to the people that are named in your will, that we commonly refer to as your heirs. So the fee that I refer to is commonly known as an estate administration tax, or even more commonly, a probate fee. Right. Now, a will, I think the best definition of a will that I've heard is a will is a written expression of a person's fixed and final intentions to dispose of his or her property on death. And what that means to me is how you would like to guide your personal representative by this written document to administer your estate. So now we know what the estate is. Now we have a written document that when you pass away tells a personal representative, or commonly known as an executor, how to distribute those assets according to your wishes.
Thank you. So let's just put it all on the table. A lot of people really don't like talking about death. They don't like talking about money. And when the death and money intersect and talking about wills, there's even more of a pause and a little bit more of a hesitation there. You talked about wills and to someone's final expression. As you go through your life, what your wishes are, who the people in your life, that changes. So what are the kind of milestones or points that people should be thinking about when they take a look at that will again? I mean, it's not a sort of one and done kind of process.
Sure. Like some of the events that are going to come up and those times that you should actually take a look at your will and potentially revamp the will. Marriage, birth of a child, unfortunately, death of a loved one, divorce, separation, even taking residence up in a different province should prompt you to see a legal professional in order to update your will or potentially have that discussion with regards to updating your will.
Jeremy raises an interesting point. I did not know that when you go from province to province, Louise, you're often dealing with people who are getting out of the military and they might be leaving the province where they are because they want to go home or want to retire in a different area. So that might be another tipping point. Can you just talk about why it's important to sort of do that periodic review?
It's important because if things change in your life, your assets are going to change. The people in your life, as Jeremy had said, will change. The last thing that you probably want is for something to happen to you and your ex-wife is on your will or your insurance. Another time to look at it, a really important time, would be when you're leaving the military, and it's on our checklist in my journal that that you should visit your CAF will and see if it's suitable for you, and it probably isn't. They're very simple wills, and yeah, so those are some of the times that are really important. And as I mentioned, insurance as well. So make sure everything's up to date. Take a look at the picture of you and your loved ones now, as opposed to 10 years ago when you actually did the first will.
And when in that transition should that happen? I mean, is this a...
I would do it periodically. When you're like before you travel, before you go on deployment, that kind of thing, and make sure that you give yourself enough of a window, because it takes time, especially now, it takes time to get an appointment, to get the documents drafted up, to have them reviewed, and then to have them signed and everything. So you need to give, I would suggest at least a good month ahead of the event. But you know, just, when you're single, who's getting your things? When you get married, who? And then when you have children, how are you going to separate that? Those are the times that would be ideal.
Because it really is just an extension of looking after the people you love, but you know,
absolutely
doing it afterwards. Are there different types of wills, Jeremy?
Yeah, so the three basic types of wills are pretty straightforward. The most common one is called an English form or a conventional will. Then there's what's called a holograph will, and within that, then there's a notarial will, and that's predominantly issued or drafted in Quebec in front of a notary. Within those, there's kind of subsectors as well with regards to, you could go online and you can get a will kit, right? That you still have to get witnessed by two individuals. But generally what I recommend every time to every CAF member or anybody is to have it legal, to have a professional will drafted by a legal professional. Have that good discussion. But essentially, there are three different types of wills: the conventional will, a holograph will, and specifically, typically within Quebec, a notarial will.
I'm gonna have to circle back. Can you tell me what a holograph will is?
I can.
What I'm sure what I'm picturing is not what you're picturing.
Yeah, so I'll actually explain what a conventional will is first. So a conventional will is generally executed in the presence of your lawyer or at least two witnesses, and the key is together at the same time. Now, this is typically specific, well, it's across provinces, but Ontario runs under what's called strict compliance. So you cannot deviate from those rules most of the time. There's a few issues or a few times in case law where judges have allowed some deviation, but effectively Ontario runs under strict compliance. So the will is signed at its end by the testator, that's the individual that's making the will, or by another person in the testator's presence if they can't sign themselves. The testator makes or acknowledges his or her signature in the presence of two or more attesting witnesses, all present at the same time. The witnesses sign the will in the presence of the testator, and in addition as well, subject to some exceptions, the testator must have attained the minimum age to make a will. Okay, so that's what they mean by strict compliance. If you haven't adhered to all of those, your will could be technically voided, right? So a holograph will kind of negates all of those things. That's why I want to explain the conventional will first, where a holograph will is entirely in the handwriting of the testator, signed by him, and you don't need to have any witnesses. So basically, it's without witnesses, so you can imagine the little surprises that might come up if somebody's willing to dispute it, right?
That's that famous scene you see in the movies when someone sort of takes out that last piece of paper and
Yes.
That's right.
changes
That's right.
everything at the end.
There's actually a very like a popular case, I forget the name of it, but an individual was actually working on his tractor on a farm, and he had fallen off, and the actual tractor had rolled over him. And yes, it's a gory story, but he had actually written out his final wishes, gets even gorier, in his own blood on the side of the tractor. And it technically was a holograph will, and it was legal.
Wow. So that's really an image I didn't need, but thank you.
I
So
A little bit extreme.
It is a little bit extreme. So when someone goes to get a will, oftentimes what you're asked is, do you want to do your power of attorney at the same time? Now that's a separate process, but often sort of gets bundled up in that will discussion. I'm going to put you on the hot seat again, Jeremy. Can you talk about what is a power of attorney? Like, are there different types, and who needs one?
Yeah, I think everybody needs a POA, depending on, what, single, married, whatever the case is. But typically a power of attorney, or what the definition is, it's a power of attorney is a document which one person grants power to another person to act on their behalf. So the technical name is, you refer to as a donor. You're kind of donating that power to the donee, or giving that power or that authority to somebody else to act on your behalf. And you could simply kind of think of a situation where a member is deployed. They need somebody to act on their behalf to potentially maybe sell a piece of property, or they're giving a power of attorney for their spouse to handle their investment accounts, right? There might be some changes. They might need to make some withdrawals. But there's many cases where an individual might need a power of attorney.
And there's two types.
Well, really, there's three different kinds of powers of attorney, but there's little variations within them as well.
So, but there you can do a power of attorney for your money, for one of them. And then there's a separate one for your health and personal decisions, correct?
Correct. So effectively, at the end of the day, there's what's called the general power of attorney. Now, this gives kind of broad power to your attorney to kind of almost do anything that you could do except make a will. You cannot create a testamentary document, because you could imagine the little surprises that would happen. But within that, there's also limited powers of attorney. You could say that your power of attorney is only for a specific amount of time. You can say it's only directed towards specific assets, for instance, selling a home, but it doesn't give broad power. So general powers of attorney, very, very broad power. Limited powers of attorney, you have maybe a specific amount of time, or it's limited to that actual area, selling a home or financial assets or whatnot. Other than that, there's something called a continuing POA. So a continuing power of attorney is when you give a power of attorney to somebody that kind of springs up when you are not mentally capable. very important as well. You can imagine a situation, again, if a member is deployed, or if you had a stroke, or you're in a coma, basically any power of attorney that is not a continuing power of attorney in Ontario will end at your mental incapacity, right? Because at that time you cannot revoke a power of attorney, so it automatically revokes it for you. So it continues into your incapacity, which is very important. But again, you have to be very careful on who you choose, because once you're mentally incapable, a lot of the times you might not be able to go back and revoke that power, because obviously you are not mentally capable to do so.
This sort of
Right.
leads into my next question, because I mean, when you're giving somebody else the ability, the authority to act on your behalf, if you're not there, say if you're deployed or if you're out of town, there's a lot of opportunities for that to go wrong. Are there other cautions that you give people when you talk about things like a power of attorney?
It is that. It is, I typically revolve around the point that you need to name somebody that you trust. Sometimes, a lot of the times, and I've been guilty of it myself, we get insurance, we check off beneficiaries, we check, it's done. But having that good conversation, first of all, maybe with your financial planner, but ultimately with a legal professional, they'll be able to kind of point out some tips and tricks or traps, right? But really, it is somebody you trust. Potentially, I often say it might not be a good idea if mom or dad is listed as your POA and they're of advanced age, right? Maybe the chances of them become mentally incompetent, they cannot act as your power of attorney if they're not mentally competent themselves. So you can't write a power of attorney unless you're of legal age, unless you're mentally competent, and thus a power of attorney cannot act on your behalf if they're not the same. So all those is just being very specific and being very mindful of the individuals that you list as POA. I hate to say, yeah.
I think there's also an aspect, and I mean, we talked about with the will, and you talk to an executor and someone who's going to sort of carry out those wishes for you, and the same with the power of attorney. It's having those conversations ahead of time. Like, you don't want someone to find out when the will is read that they are your executor, correct?
That's it. So letting them know where the will is, where the powers of attorney are, right? Having that good conversation with your lawyer, and having a copy there, maybe having a copy with your financial advisor, maybe having a copy in your safe at home as well. But obviously, yeah, a lot of people don't actually realize that they've been listed as the executor or the personal representative, or they don't know that they've been listed as the power of attorney, as the POA for an individual's will, or to take care of their financial affairs, right? I did want to touch on, so that last power of attorney is the power of attorney for personal care, right? So the power of attorney for personal care is a little bit different. It allows you to give instructions to potentially doctors or loved ones concerning healthcare issues in the event that you subsequently become unable to make such decisions for yourself. So that's the third one.
And again, really important to have those conversations so that person knows what you would want if that situation, because in essence, they're speaking on your behalf when you can't.
And again, having that conversation, Ontario is changing drastically with regards to end of life decisions, right? We're becoming more on track with Quebec as well. So with regards to assisted suicide and whatnot, it's changing a lot. There's a lot of change. It's constantly changing. So yeah, that's a good one as well. But it really starts with having those in-depth conversations with your loved one, your POAs, your personal representatives.
And you talked about changes to the to laws around death and assisted suicide. But before the conversation started, before we started recording, you were talking about some changes that were actually happening in laws around wills. So, if you do will 5 years ago, according to the letter of the law, then sometimes changes happen, and that doesn't necessarily, the laws have changed since that's happened. Do these changes happen a lot?
They do. Most of it comes like because we are common law. It's based on case law. There's arguments that come about. There's been some wonky ones in the past year, especially with COVID. There's been changes that have been positive, being able to sign wills virtually with a lawyer, which we 10 years ago or even 5 years ago, we never would have thought to be the case. Another interesting one that is potentially looming or right around the corner is one with regards to marriage. In Ontario, if you're married, or sorry, if you are entering into a marriage and you have a pre-existing will and it's not in contemplation of marriage, and specifically to that individual that you're getting married to, your will could be void. So it could leave you with what's called or being intestate, or being without a will, right? But there has been a bill that's been introduced. I'm pretty sure it will pass, Bill 245, if I'm correct. But effectively, what it's going to do, or what it potentially might do, is that might not be the case. A marriage might not revoke your will, which is very important. Now, sometimes that's good, sometimes that's bad, sometimes that's not so good, right? Now, if everybody was aware that their will, if marriage voided out a will, then that might be a good thing. But not everybody is aware of that. So if we have a pre-existing will and now marriage may not revoke that will, those changes, that marriage should have potentially changed what that testator's wishes are, right? You may have children that need to provide for, dependents, and that's one of the things with will planning and estate planning. In Ontario, we have a certain degree of what's called testamentary freedom, right? The ability to kind of distribute our assets at death the way we want to, but we have to maintain, or have to keep into consideration, that there's a limit there. We have to still make sure that we've taken care of our financial dependents, whether that be a spouse or children. So making it too broad, we could see, well, at the end of the day, just like any other change, we'll see what happens.
Absolutely. So a lot of this is really centered around conversations and really being open with the people around you about what you want and how you see things unrolling in your life. Louise, you have a tool that is available for families who are transitioning that really talks about a number of different issues beyond wills and power of attorneys, but other issues that maybe you should be thinking about and talking about with your family. Do you want to talk about that a little bit?
The Veteran Family Journal is that tool. It has a lot of information. It has a lot of information pre and post. It has a section where you can write down service providers, who your power of attorney is. It has checklists that talk about, when you're releasing 18 to 12 months before, have a look at your will, have a look at, your situation, and it goes right up until after release. It has connections. It talks about SISIP, it talks about VAC, it talks about different programs. It gives you an example of a budget that you can look at with SISIP's logo on top of it. So it really is a wonderful tool, and you can use it as an organizational tool. And it's a living document, really, because you can make it what you need it to be. And you're not going to need all of the information the day that I give you that journal, but 5 years down the road, you might need something in that journal. So it's one of those things. I was talking to somebody last week, and they said their husband medically released, and it was pre-journal, but she gave him a binder and everything. He still 3 years later carries that binder to all his appointments. So
and if you have stumbled on this session and you are a serving military member and you are not in that transition period, you're still in, but you're thinking about these types of issues because there's a deployment in your future and you want to get things set so your spouse can look after things while you're gone and get that power of attorney, and sort of look at some of those other questions around things that people should know while you're away, everything from home maintenance to car maintenance to where the RSPs are. There is a binder that the PMFRC has called the deployment binder. So that information is available. So if you are away on a deployment and someone can't reach you and a financial decision has to be made, that they have the information about where things are that they need. And I think more than anything, it gives you peace of mind. Does anybody have anything else that they want to talk about before we go? Any last thoughts or encouragements?
Even though the conversation may be uncomfortable, have it. It's better to be prepared than to be sorry. And it's going to be your family that has to deal with it and pick out all the knots if that conversation isn't held.
Thank you, Louise. I think that's a good point. Jeremy, that's a tough one
Yeah.
to top, but I'll give it to you.
No, I was just about yeah, just I mirror exactly those points. Like a well drafted will, especially by a legal professional. Stay away from will kits. You know, develop a great estate plan with the help of your financial planner. You know, and you know, obviously go see your lawyer. And that's it. Really, it's just having that in-depth conversation, making sure your wishes are put down on paper, right?
Thank you all. I appreciate your time and joining us today. So this has been the latest installment of Demystify Your Transition. There are other parts, 4 other series of information. So if you saw this one first, contact Louise. Louise can give you a list of the other ones that have been recorded already and maybe give you a tip of what's coming in the future. So thank you very much for joining us. Thank you, Jeremy and Louise, and have a wonderful day.
Thank you.